This is the American Law Journal.
If you're seriously hurt at work, what does a good lawyer do to maximize your benefits? It might mean going outside the system. Good evening, I'm Christopher Naughton. Welcome to the American Law Journal. And if your lawyer is not looking at someone other than you or your boss or maybe a coworker, he might not be doing his job. Caveat emptor, let the buyer beware, and that comes to buying or picking lawyers as well. Three of them, or actually two attorneys and a judge, are with me on the set tonight. George Beatty hails from Beatty, Sloan, and DeGeneva, a claimant's attorney representing those injured in personal injury matters, product liability, medical malpractice, and indeed workers' compensation, with lovely offices there on Locust Street in Center City, Philadelphia. The Honorable Todd Seelig joins us for the very first time this evening, a workers' compensation judge and also an adjunct professor at Villanova University School of Law, where he teaches workers' compensation. And Lori Carroll is with us this evening from Nolte, Skarkamaza, and McDevitt. She represents the insurance companies, the self-insureds, and the employers, and has been in practice for just about as long as George has been as well. Well, most of us realize that if you've been injured on the job, if you do get workers' compensation, you're not going to get everything you'd get, let's say, in a personal injury matter. You're only going to get about 2/3 of your salary. You're going to get your medical benefits. You may get specific loss for a body function or a body part, please forgive me, but no pain and suffering. So the system, look, we've been over this a million times. The system was never set up to make you whole.
That's right. In 1915, when the law was first passed here in Pennsylvania, there was a trade-off. You don't have to prove that your employer was negligent. You don't have to prove that they were at fault. And even if you're at fault yourself, as long as it was just something careless and you get hurt at work, it's a no-fault system. So you gave up your right to get your pain and suffering and many other damages that you'd have at common law. But in return for that, it's more of a guaranteed liability.
Right.
I think it makes you whole if you consider workers' compensation as an insurance policy that protects you. It protects your wage loss and it protects your medical. So in that, that's what it's for.
Right.
So if you look at it like that, it does make you whole.
Well, it doesn't in the sense that there's no cost of living increases. If a person is seriously injured and they're really in bad shape, they get frozen in time at a low workers' comp rate. Inflation eats them alive. And now with the new IREs that were put through in a Republican administration, they can stop somebody after 500 weeks, even if they're still horribly disabled. It's just a bad system in that sense.
But that person can be on workers' compensation benefits for the rest of their life unless they make an agreement with their employer or a judge finds that they have fully recovered and they can move on with their life.
I don't think George is saying it's a bad deal. I think what he's saying is don't expect your entire salary. And if you have loss of consortium, you have problems, in your romantic relationship, if for some reason, you've got bad pain and suffering down the line, don't expect that workers' compensation is going to take care of that. And that's part of the trade-off.
Chris, if I could just
absolutely, Judge,
jump in. When I teach this at Villanova, the first class we talk about was a great compromise, and there's many work injuries where you can't prove fault, and that was the problem with the whole Industrial Revolution, and people were being injured. And what was their compensation? They couldn't prove someone was at fault. If you think of many workers' compensation injuries, you're picking up something, you hurt your back, even a carpal tunnel injury. Who would you sue and say, you're at fault for my injury? So the trade-off was certainly a trade-off in terms of this compromise where the claimant didn't have to prove fault now, just had to prove there was an injury and it was within the scope and course of employment, obviously. And obviously, the trade-off was now I don't get pain and suffering, I have limited damages, and hopefully a more speedy recovery.
But Judge, you know this, that if lawyers are not looking how to maximize benefits, whether it's in workers' compensation or getting outside the system, they're not doing their job. You know better than I do that when workers settle for a comp case, we rarely see anything over $200,000 or $250,000. Isn't that correct?
Yes, I would say in Pennsylvania, where we all practice, it's very rare that you'll see a workers' compensation case settle for, even over $150,000, $200,000. Right. And the reason for that is it really is all about the wage loss. The worker receives essentially 2/3 of what they used to make, and that's really, when you're looking at the monetary value of the case, that's what you're looking at. What did the worker earn? And you're only going to get 2/3 of that, and that's even capped you know, in the $800–900 range, depending on what year your injury occurred.
So again, when people do get injured and they've been injured because of the negligence of another and has nothing to do with a work injury, they see an attorney, and sometimes they're talking hundreds of thousands, maybe into the millions. And I guess that's what we're talking about here. We have the same exact injury. One takes place at the workplace. One takes place, let's say, in a car accident, but two completely different settlements. So it really is incumbent upon the attorney to do their homework to make sure that they're maximizing those benefits or getting outside the system, because otherwise that party is going to be at a loss.
I think you always need to look at the circumstances of the injury. How did the injury happen? Was there a third party involved? And it's not always necessarily a third party. It could be a product that was defective. A machine didn't have proper guarding. It wasn't designed safely. It could be a landlord that didn't clear a sidewalk, or there's some kind of a tripping hazard that causes a person to get hurt, not on their employer's premises, but on a landlord's premises. There could be a motor vehicle accident. There's a variety of things that can happen where you're still in the course and scope of your work and it's covered by workers' comp, but you may also get outside the system and file a lawsuit against a third party and get all of your damages. And then, you know, I'm sure Judge Seelig and Laurie will chip in on this when we talk about that. There's a thing called subrogation, where the insurance company for the workers' comp has a right to come in and take some of that money back. But, you know, it's our job as claimants lawyers to take a look and see the big picture. Is there a way of getting outside the system to maximize recovery for my client? I do that every day.
Okay.
And I am sympathetic with an injured employee, and I do believe good counsel for the employee should always attempt to maximize and benefit that employee in the long run. So in my practice, most of my cases only happen when an employee is lifting too much, or they're pushing too much, or they're typing too much. But there are those occasions when there may be a potential third-party suit there because the employee is driving a car on behalf of the employer and someone hits the employee. That's a third-party suit. That's a motor vehicle accident where if that employee was not negligent, that employee can sue the negligent party. Yeah.
And the insurance company can get their money back. So when I have a case like that with Laurie, for example, I'll call Laurie and say, whoa, whoa, whoa. Tell the insurance company to back their dogs off. Don't send them to some kind of doctor that's going to say they're fine, because you're hurting the third-party case. And if you want to get your money back, you know, Laurie, we know how these things work. And sometimes you could push down the workers' comp carrier and they won't be as aggressive if they know there's a light at the end of the tunnel in the third-party case.
Well, we're going to get down to the bottom of it. I'm a firm believer that not everybody is injured for the rest of their lives. So I'm going to go through that process to determine what stage, what progress that person has made regarding their health and have they fully recovered. Now, sometimes I may conflict with George if there is a third-party suit out there, but I would not be doing my client any justice if I I became negligent and didn't do anything. So
you don't know
better.
how the third-party claim is going to ferret out.
Right.
So you basically have to move down the track and represent your client's best interests.
That's right.
Which may mean, you know, the comp benefits may be tamped down a bit. You're obviously going to try to, you know, be fair, but at the same time, you're not going to open up the vaults from your client, who's the insurance company. And you're going to watch that. But at the same time, it does behoove you, does it not, if George's client has been hurt by something other than a work injury. Again, they get hurt with a faulty product. They get electrocuted by something that hasn't been properly covered at work. They have a forklift injury and there's some sort of design defect with that forklift. It's your hope, of course, that ultimately your client doesn't have to make the payments for the workers' compensation injury, that a third party is going to end up paying that tab.
All right, and that's very beneficial for my employer, and I let them know that because, we can recoup a portion of the wage loss that we have paid out. We can recoup a portion of the medical benefits that we have paid out. And so, when there is a third-party case out there, I'm very happy, and I let my client know, and they are also happy because, that's money back into their pocket.
And
Judge,
Chris,
go ahead, Judge.
I just jump in. Where we usually see this is, of course, the Workers' Compensation Act says if the injury was caused in whole or in part by a third person, somebody else other than the employer, the employer is subrogated, basically can recover from that third-party recovery, and that's why we call it, third-party subrogation. And a lot of times we see this where there's an injury and the injury hasn't been disputed in workers' compensation. The claimant actually gets on workers' compensation, is receiving benefits, but at the same time they have this third-party case going. And then the question is, when we start talking about maybe settling the workers' compensation case, what do we do with that third-party case? And that becomes, a very interesting topic in terms of settlements, especially in Pennsylvania now. The law changed in 1996 where you can settle the entire case, both wage loss and medical. And so we have much more of a culture of settlements in workers' compensation. And these third-party subrogation issues come into play a lot in settlements now in workers' compensation cases.
It's crucial.
And George doesn't want to give me my money many times.
Right.
And I have to follow him. I don't follow him, but I have to make sure that he gives my client their due.
It's crucial. What happens, and it's a good thing, if your third-party lawyer is the same lawyer as your comp lawyer, he or she will try to make the deal in the comp court in such a way that they either waive their lien, limit their lien, line up their lien in advance so we know what we're dealing with. Because the difficulty is, if I'm going to go pick a jury in a third-party case and I have a $500,000 comp lien, it's very difficult for me to try to settle that case if Laurie's going to call me up the next day and say, oh, I want all my money. So if I could settle the comp case in advance or make a deal in advance with Laurie so I know exactly what I'm dealing with when I get into court. I've had situations where the jury's in the box, settlement offer is made, we go back in the chambers, and I say to the judge, you got to call either Laurie or somebody that's in her shoes to come to court, and the judge orders them to come, and they have to come there and they have to pick up the phone, and we make a deal.
And before I waive anything, I want to know everything.
That's right.
I want to know the amount of the settlement. I want to know how the litigation is progressing. Is there a strong case on behalf of the claimant? Because that means he's going to get a lot of money, so why should my client waive their lien? However, I want to know if it's a small settlement, and we can finagle some ways where we could settle the third party, and especially if there's pending litigation, we may be able to terminate benefits the other way and get supersedious.
So you may waive some of your lien
we can
there,
waive.
but you probably get to know who you can trust and who you can't trust. And if somebody burns you once, like, oh, there's not much money here, Attorney Carroll, you find out. And later on, it's like, what did you, excuse me?
I've had lawyers
then I'm very
come to trial.
unsympathetic.
I've had lawyers come to trial. I had a trial not that long ago where there was a lien. It was 150, 120 in that range. And the lawyer, in Laurie's shoes, came and sat there and watched the jury trial. It was fun, and he was getting paid, I guess, to watch it. But and then, and then we won a big verdict. We got a verdict of way over $2 million. So they got their whole lien on that one. And that was a case, in another case where you can make a settlement in advance and say, you'll take this much of your lien rather than all of it, and, or you make some kind of a formula based on what you recover. Creativity, the sky's the limit, and we've been doing this for a long time.
That's my whole point. It does really take some creativity, and you guys are on different sides of the fence, but especially, again, when a third party's involved, even more than when you're just discussing settlement, you have to work together, and you actually have to get creative. And I know that causes some problems sometimes, because we hear from people that say, my lawyer's getting a little too chummy with that other lawyer over there, and they're sitting in the corner and they're talking and they're laughing, and they almost feel like, are they on my side or are they working together?
Oh, that happens. I always have to tell my client, because I've been doing this for a long time, and people like Laurie and I get along great, and we get in the courtroom. We're not always real nice,
Not
at all. But I can trust her. She trusts me. We're professionals, and we're friendly. And I tell my clients, the workers' comp bar is very collegial. Everybody gets along pretty well. It doesn't mean we're going to sell anybody out. Quite the contrary.
Judge, let me ask you a question. Because I find this really hard to believe. And George mentioned before that when there's a third party claim, sometimes it's good when a lawyer handles the workers' compensation matter and the personal injury matter. But I've heard stories where people show up in maybe your courtroom and they have not done their own due diligence to see if their injured claimant, their client, in a workers' compensation matter has a third-party claim against someone else out there that may ultimately be responsible for that person's injury. Are you as incredulous as I've just expressed it?
Well, I think part of the issue is as we're getting more specialized, and we're starting to see attorneys that just do workers' compensation as opposed to both doing personal injury and workers' compensation. I think that sometimes there can be things that are missed, and certainly as Mr. Beatty said, that you really have to look at the entire case and also look at it from a strategic standpoint in terms of where do you want to be potentially with your first lawsuit. Do you want to be in workers' compensation, or do you want to be in your third party, whether it be common pleas court or federal court or something like that? Because sometimes you can be, almost arguing different points, and you have to be careful that you're taking different positions in different courtrooms. So that does happen. And the other point I wanted to make is in Pennsylvania, the employer is in a very powerful position in subrogation. The law basically says that the lien automatically attaches once there's a settlement. So someone like a claims attorney like Mr. Beatty would definitely have to go to Ms. Carroll and say, let's try to compromise this lien, because once it's settled, there's absolutely no leverage for a defense attorney to compromise that lien, because under the law it automatically attaches. Even if the employer in the third party case was negligent, that doesn't matter. It automatically attaches.
Okay. I'll sound like a defense lawyer when I'm talking to Lori, and I'm going to say, I have this third-party case, but this problem with it, this problem with it, we got a good chance of losing. This may happen, that may happen. And I sound really like a naysayer because I need to point out all the negatives to Lori, because that's my leverage. My leverage is to say, no deal, we go to verdict and we lose, you get nothing. Or do you want to, if you let us settle for X dollars, we'll give you this much, not your full lien, but at least you get something back. And it depends on the dynamics of the situation.
Right.
The best case scenario is like what happened in that case where the lawyer came to watch, and we won a huge verdict, and they get their full lien, and everybody's happy except the third-party defendant's insurance company.
And I need George to be realistic, because I have to go to my client and give them the realistic outlook of the case, because I'm not the person who's making the decision. The decision is my client's making the decision. And so I have to let them know how great George's case is or how bad George's case is.
And I would have to think too, Lori, that occasionally, I mean, with less insurers out there, and there are lots of mega companies, that every once in a while, your company, you're representing a company in the workers' comp case, all of a sudden they're also involved in the third-party claim. They may be representing both. Now all of a sudden, you can't play both sides against the middle.
That's right,
there.
and that's what George says. He's very correct. You put up a wall, and I think that's a very difficult position to be in. But when usually the workers' comp people are on one end of the office, and the liability people are on the other end.
And would be a different law firm too.
And it's a different law firm that even handles that.
It's very interesting because Lori, as a defense attorney, is often trying to limit the claim and trying to get medical testimony through an independent medical exam to say that the claimant, has some sort of earning capacity, could maybe go back to light duty work if not fully recovered. And yet that potentially could hurt the third party case because, again, claimant now has been examined by another doctor, and that doctor now has an opinion that maybe claimant is not quite as disabled as Mr. Beatty is asserting in the original claim. So there is kind of, does one hand know what the other hand's doing? And very interesting things can happen when you've got both a third-party case and a workers' compensation case going.
I always make sure that the defense lawyer from the comp end knows, especially if there's a big lien. I have a lot of these cases where there's hundreds of thousands of dollars that have been paid out in medical bills and to some extent wage losses by the workers' comp carrier. They're sitting there with a lien worth hundreds of thousands of dollars. We have a potentially seven-figure third-party case. And normally, if there was no third-party case, Lori would be sending people for IMEs, or they start to pester the person.
Independent medical exams.
Right, sorry. And, and I say to them, whoa, not this case. Look at your lien here. Do you want to manufacture bad evidence that's going to be grabbed by the third-party defendant to come after us with? They only get one bite. They get one exam, and if they pick an honest doctor, they're in trouble. So.
But see, but this is what we discussed before. You're at a conflict or at a fork because does the employer's counsel do nothing? And because we don't know. We can't anticipate what the verdict is going to be. You can't anticipate the defenses. You can't anticipate at that juncture. I would be hard pressed if it was time for an IME. I would be hard pressed to say to my client, let's not get one, because the third party case can explode. I mean, it could go on for 2 or 3 years and explode, and then I have a client who hasn't had an IME of an employee for 2 to 3 years. And that's damaging to my client.
A lot of times what will happen is that'll force us to the table in the comp case, and they say, all right, look, the injury's severe. We have all these bills
The
out there.
higher value,
and it's
because
got-
I don't have an IME.
Right.
But go ahead.
So we're going to give you X amount of dollars, and then we're going to get back so much depending on how much the third-party case goes for.
Right.
And that's completely up to negotiation and creativity. There's all kinds of things that we can do. I have them assign their lien to us so we can put that on the board, so to
Got
speak,
it.
in
Got
front
it.
of a jury. We do all kinds of creative things that maximize our client's recovery, while at the same time acknowledging the right of the workers' comp insurance company to get some of their money back. So if we do it right, it can be a win-win for Laurie and me.
And that's true.
And again, but you have to know the other attorney that you're dealing
you
with here.
definitely do.
You have to know that they're good in a personal injury matter, that they
Yes.
can take this case to a jury, they can try the case in a court of law,
Right.
and then when they come out, that either they're going to get a great settlement or the jury's going to come back with a nice figure.
Right.
And so you have to feel confident even before
I look
you-
at the past history of working with that attorney. If it's a new attorney that I
But the-
don't know, I'm a little bit antsy.
I was going to say, because
Yeah.
nowadays you're going to see more new faces. They're
Right.
going to crop up. The bar is not quite as small. Workers' comp bar is not quite as small as it used to be.
Right.
Sure, there's some familiar faces there, but you can assess what they can do. Go ahead, Judge.
Chris, I wanted to jump in too. The lawyers really do have to work together. I think that's an excellent point because in Pennsylvania, only the claimant can pursue that third-party case. So let's say the defense counsel, let's say Ms. Carroll sees a third-party case, would like to pursue that, to recover money for her client, and yet the claimant is not interested in pursuing that third-party case. She cannot do that on her own. So really, the attorneys need to work together.
Why would the attorney not be interested, even if they're not? Let's say, I understand that some people are specialists. They're only doing workers' comp. Don't they go and get a personal injury attorney to represent this guy in a personal injury matter? Isn't it going to help that attorney as well?
It's rare that it happens, but I have seen actually where people have researched the issue to see if the defendant could actually bring the third-party case because they thought a third-party action existed. But I've seen one where there's a third-party case where it was really a lawsuit against a family member. And they did not want to bring it, even though it was probably a viable case. So there were some sort of, different types of facts, personal facts, that the family did not want to bring the third-party case against this particular individual, this particular business. Maybe it was a family business or something. And so the defendant really thought there's a third-party case, wanted to bring an action, and the court said no. The claimant, only the plaintiff or the claimant can bring that action. A defendant can't. So that's why, experienced counsel will work together in these cases.
Do you get burned sometimes, Laurie? In other words, you really think that a case is going to come in, it's going to cover your insurer, and you find out at the end of the day, not George per se, but a plaintiff's attorney goes up to bat, goes in front of a jury, and they come back with nothing. But you're really not out much, are you?
Well, if you don't expect...
You're no worse off than if the guy had just gotten usual work.
Right, that's what I'm saying. If you don't expect any money...
You're playing with
then
house
you're not
money.
right, that's right.
She is playing with house money,
You're playing
isn't
with
she?
house money. If you
Right.
don't expect any money, you're not worse off
Right.
at all.
Okay.
But no, I've never been burned, Chris.
All right.
As always, no.
At least check your facts. Judge, you mentioned something at the top of the show, which I'd like to broach. And you talked about a culture of settlement. Now, again, we've talked about third-party claims. When you get a good, creative attorney who gets outside the system, they can get bigger dollars for their client. But that's not always the case. Sometimes you're hurt on the job. There's no one else that's liable here, so you got to go through the comp system. But the system has moved in the last 20 years to settle cases. So when you say a culture of settlement, what do you mean?
Well, I think the...
I don't know if there's an innuendo in there or not. I'm trying to get you to come out and say something.
Right. Well, it's pretty clear in the law. Actually, before 1996, it was actually illegal to settle a workers' compensation case. So you weren't allowed to do it. Now, we had something we'd call commutations, where we'd find the claimant had an earning capacity. We would commute that forward, but you, in theory, were not settling the case, and you were not allowed to settle medical benefits. So when I say a culture of settlements, there really was no culture before 1996. I mean, there was certainly, we would call them settlements, even though the act would not, and we'd be commuting benefits. But after 1996, and I think part of this was a response to a lot of cases, some backlog in the system, and also a trend nationally that allows the entire case, both the wage loss portion of the case and the medical portion, to be settled. So after 1996, we put the Act 57 of 1996 put in the compromise and release vehicle, and that allows us now to settle the case. And also, as Mr. Beatty indicated, you can be very creative because you can put all kinds of language in there. Talk about the third-party case, compromise the lien, do different things with medical. You can set aside a certain amount of the settlement and say that's
Yeah, but
designed
Judge,
for
from what
claimant.
I'm hearing, though, and again, I know you can't get involved in politics, so I'm not posing this question to you, but from what I'm hearing is, certainly claimants are saying this, claimants' attorneys, is that over the number of years that settlements have become a little bit more pro-employer. For example, that they're riding on the large pot of money, so they've got they've got a little leverage there, number one. Secondly, they are asking people to resign, so we've got these settlement resignations that are coming up. They're telling people, look, if you want your comp money, you can't go out and sue a third party who may be a client of mine. So those are being included. The kinds of things we used to see in personal injury settlements, confidentiality, don't sue a third party, a resignation, that sort of thing. We're now starting to see them in workers' comp.
They're really not supposed to be part of a workers' comp settlement.
But they're there. There are cases that have gone before the Pennsylvania Supreme Court that says that, for example, I hire a person. They work as a security guard for my company. I send them off to work for, let's say, Sunoco Oil, and they get hurt over there. But part of their agreement is, you want workers' comp, you don't sue my client. Those kind of settlements have become, let's say, a little bit more politicized over the last 10, 15 years.
Right. See, I look at settlements as more of a closure. It's emotional closure and physical closure to allow both the employee to move on with their life, and it allows the employer to move on. So I don't think settlements have become pro-employer. I think settlements have become manageable for all parties to allow parties to come to a mutually agreed value of the case that they both will be satisfied with, so they both can move on. And I think that's a benefit. I think that's a benefit to the employee. I think it's a benefit to the employer.
As long as your guy has enough money that 5 years from now, he's got more medical problems, and he comes back to you and says, Attorney Beatty, I don't have any money left, and I still have medical bills.
The devil's in the details. Like Laurie said, you want to have closure, but you want to have good closure. You want to have financial closure in a way that embraces the employee's needs, in a way that you could sit down and talk about the big picture, not just medical bills, not just wage losses, but how old are you? What do you plan on doing? What's the family situation? Look at the person as a whole and decide, let's get closure, but let's get good closure.
And I think that does go to the importance of getting a good attorney, getting good counsel, because actually with that settlement, the amendments that came in 1996, they actually changed the standard for what a judge reviews. The judge still reviews the settlement, but only decides if it's the claimant understands the legal significance of the agreement. The old standard before 1996, when you commuted benefits, you still weren't giving up your medical, was it in the best interest of the claimant? Yep. That's no longer the rule, or the statute has changed now. So really, we're somewhat relying on counsel to make sure that they're confident in settling this case, because they know this case much more than we do, and we want to make sure that the claimant understands the legal significance of it. And we try to do the best job we can in that area.
I want to thank all three of my guests who had a collegial and very cordial conversation tonight, despite having some distinct differences. George Beatty, claimant's attorney with Beatty, Sloan, and DeGeneva in Center City, Philadelphia. The Honorable Todd Seelig, workers' compensation judge and adjunct professor teaching workers' compensation at Villanova University School of Law. And Laurie Carroll joining us for the very first time tonight, although we've seen partners of hers, Nolte, Scaricamaza, and McDivitt, representing the insurance companies and the employers. You had a good time. You look like you were smiling most of the time.
I had a great time.
You only hit George once, and we've already cut that out. Folks, thanks for joining us. We're here every Monday night dispensing legal advice, and for all of us here at the American Law Journal, thanks a lot. Until next week, case closed.
This week's American Law Journal has been made possible in part by Beatty, Sloan, and DeGeneva. Decades of experience providing personal attention to those injured at work or suffering from serious injury due to medical malpractice, defective products, motor vehicle accidents, and other causes, with offices in Philadelphia and Haddonfield, New Jersey. Nolte, Scaricamaza, and McDivitt, a full-service regional defense law firm focusing on a broad spectrum of litigation matters, including workers' compensation, employment practices, and other complex liability issues. Philadelphia, Media, Marlton, and Wilmington. And The Legal Intelligencer, the nation's oldest legal newspaper for lawyers.